looking at intersectional approaches to investigations and prosecutions. My name is Angela Mudukuti, and I'm very pleased to be here and very grateful to the organizers for inviting me to facilitate this discussion. And speaking of the organizers, I'd like to thank the Transitional Justice Institute at Ulster University, the Unit for Global Justice at Goldsmiths University, London, and the Emergent Justice Collective, Thank you so much for bringing us all together and for being pioneers, facilitating this key discussion and creating spaces for exchange and learning about intersectionality in ICL. Just a few housekeeping items before we get into the exciting and interesting parts. The webinar will be recorded and will be made available on the Emergent Justice Collective's YouTube channel and via @IntersectionICL on Twitter. That's @IntersectionICL on Twitter. There will be live tweets, there'll be live captioning, and the format today will be conversational as I engage with our very impressive panel. You'll see that some of the best and brightest in ICL are with us here today. Then we'll have a Q&A session, so please get your questions ready, type questions in the chat, and they'll be sent to me by Lily, who is monitoring our chat today. Thanks, Lily. So now that all of that is out of the way, I'm very happy to hand over to Amanda, who's kindly agreed to introduce our speakers today. Amanda is an ICL expert, lawyer, and freelance consultant, and she'll be moderating webinar 3 in February, so look out for that as well. Thanks so much, Amanda. Over to you.
Thank you very much, Angela. I'm delighted to be here today with the honor and the pleasure of introducing our brilliant participants. I would like to first start with our wonderful moderator for this session, Angela herself. Angela is a Zimbabwean human rights lawyer specialized in international criminal law. She has worked for a number of organizations, including the International Criminal Court, Open Society Foundations, Human Rights Watch, the Wayamo Foundation, and the Southern Africa Litigation Center. She focuses on strategic litigation, advocacy, and capacity building, and her work has ranged from training prosecutors and investigators to enhance domestic capacity to tackle international crimes, to also working on universal jurisdiction and precedent-setting cases before South African courts, including seeking the arrest of the former president of Sudan during his visit to South Africa. She has written and published on international criminal law in books, journals, and newspapers, and has been featured in the media, including the Financial Times and Al Jazeera. And she also sits on a number of editorial committees, including the Oxford Journal for International Criminal Justice and Opinio Juris. Next, we have Sareta. Sareta is a barrister specialized in criminal and international criminal law with expertise in the gendered commission and impact of international crimes. She is deeply involved in case building work for crimes committed in Syria and Iraq, and has worked on United Nations investigations into ISIL crimes against the Yazidis in northern Iraq, which culminated in findings that ISIL committed genocide and crimes against humanity. In 2018, she wrote the Global Justice Center's landmark report, Beyond Killing, Gender, Genocide, and Obligations Under International Law. And today she continues to advise on gender competent and intersectional analytical approaches to the documentation of international crimes. She's also a visiting fellow at the Blavatnik School of Government at the University of Oxford. Next, we have a fellow Canadian, Valerie. Valerie is a full professor at Western University's Faculty of Law. Her research and writing focus on gender issues within international criminal justice, and she has published and presented widely in this field. She is the Associate Director of Western Center for Transitional Justice and Post-Conflict Reconstruction, and a member of the Canadian Partnership for International Justice. Before joining Western Law, Valerie served in the Legal Affairs Bureau of Global Affairs Canada, and in this role, she provided legal advice on international criminal law, and she served on the Canadian delegation to international criminal court-related negotiations, including the Rome Diplomatic Conference, preparatory commission meetings, assemblies of state parties, and the 2010 Kampala Review Conference. Next, we have Maxine, who I understand also goes by Max. Max is an international criminal prosecutor and investigator with 24 years of field-based and courtroom-based experience in international criminal practice. She has carried out field-based international criminal law work in 13 countries and contexts, and has spent 9 years as a prosecutor at the ICTY and 2 years as a criminal investigator at the Special Court for Sierra Leone. Max has served as an international criminal law or gender advisor to 3 international commissions of inquiry and serves on the faculty of the Institute for International Criminal Investigations. She is the 2018 recipient of the Prominent Women in International Law Award by the American Society of International Law, and she also directs Partners in Justice International, which provides technical mentoring for national prosecutors, investigators, and victim lawyers on cases involving war crimes, crimes against humanity, and/or genocide, helping them bring justice to victims in their own national courts. And finally, last but certainly not least, we have Priya. Priya is a Malaysian lawyer specializing in international criminal law, human rights law, and gender. Her expertise is in international criminal prosecutions, strategic litigation, advocacy, and human rights investigations. Her work has included operationalizing transitional justice measures such as reparations for survivors of sexual violence and developing best practices for working with survivors of international crimes. Her experiences span from Kosovo, Bosnia, Croatia, Ukraine, Georgia, Armenia, Moldova, Sri Lanka, Syria, the Gambia, and much more. Priya was a prosecutor and appeals counsel at the UN International Criminal Tribunal for the former Yugoslavia, where she had a leading role in cases that set progressive legal precedents on conflict-related sexual violence. She played a pioneering role as the first legal advisor for sexual and gender-based crimes at the International Impartial and Independent Mechanism for Syria. And she served as the gender advisor for the OHCHR investigation on Sri Lanka and the senior advisor to the Truth, Reconciliation, and Reparations Commission of the Gambia. In 2021, she was appointed by the UN Human Rights Council to the UN Working Group on Arbitrary Detention and currently serves on the working group as the representative for the Asia Pacific. So as you can see, we have an incredible, fabulous group here. And with that, I will pass it back to Angela to get the session started.
Thank you, Amanda, for introducing our panelists and for joining us briefly today. Really appreciate it. So as was explained in webinar 1, the concept intersectionality was coined in 1989 by Kimberly Crenshaw to provide a multidimensional framework for anti-discrimination law in the US. And the idea was to acknowledge that discrimination of Black American women was multidimensional, and it simultaneously included not just discrimination on the basis of race, but sex and class identities as well. In short, Crenshaw highlighted that, and I quote, "the need to account for multiple grounds of identity when considering how the social world is constructed." So taking this and applying it in an ICL context is precisely why we're here today. And unpacking intersectionality in ICL can give us a fuller and more comprehensive understanding of experiences of affected communities and help us approach accountability in a more thorough and meaningful fashion. So although we've seen ICL jurisprudence with some traces of intersectionality, we see that the ICL practice tends to homogenize protected groups. And this one-dimensional approach can cause harm and lead to a failure to adequately address the experiences of victims and survivors and to truly provide accountability. In listening to the first webinar and in thinking about intersectionality myself, I quickly realized that everyone has a different understanding of what it is and how it should apply and how it can be taken into consideration. And so I thought for this chat, we could start by laying a foundation as to what our understandings of intersectionality are. And with that, my first question goes to Max and Sareta. We'll start with you, Max, if that's all right. What themes come to mind when you think of intersectionality and your understanding of its application in ICL investigations and prosecutions? Thanks, Max.
Sure. Thank you so much, Angela, and to everybody for joining together. It's wonderful to connect with all of you, and I really look forward to our exchange. I think what comes to mind immediately for me is that if we're truly being victim-centric, right, we talk about being victim and survivor-centric, and we're still having to explain that sort of what do we mean by victim-centric and how do we do that. We should by nature inherently be approaching people with an openness and understanding that their experiences are not necessarily going to fall into boxes or categories that are set by anyone. And it's our sort of obligation. I say our, but I'm essentially talking about practitioners who do investigations and prosecutions, whether international practitioners or national practitioners, right? All of us have an obligation to focus everything we're doing around the experiences of the victims and survivors. If we do that honorably and honestly, we will necessarily see the multidimensional impact that these crimes have on individuals, and also and on their identities, but also the fact that each person will make a choice about how they want to talk about it, about what they want to emphasize, about what harms they want to have remedies for. And it's really our obligation to tailor whatever work we're doing to that reality. You know, now I think that there are some aspects that we may not be able to get around, right? There are some aspects of practice that, you know, that are, sorry, did somebody want to come in? No, okay.
Also, please.
Sorry, I misunderstood. Okay. I know we're going to have a bit of a dialogue in here, so that's fine if anyone wants to jump in. I think there are some, let's say, some decisions that have to be made and some choices that have to be made in prioritization in the course of investigating and prosecuting. That is true, but I'm a very strong believer in the fact that law is meant to bring justice, and the justice we're bringing is for the victims and survivors. Therefore, it has to be adapted to their reality, their needs, their experiences. And there may be times where it cannot address that, but I believe those times will be few and far between if we approach everything that we do with a view toward addressing victims and their needs and the harms that they experienced in whatever form that is, in all dimensions of how they experienced it.
Thanks, Max. Sareta, I don't know if you want to jump in with your thoughts on that, please.
Sure. Thank you. It's good to be here. Good morning and good afternoon to everyone who's listening. Intersectional theory asserts that people are often disadvantaged, usually simultaneously, by multiple sources of oppression, whether that's race, class, gender identity, sexual orientation, religion, class, and other identity markers. These markers don't exist independently of each other. Rather, each informs each other, creating, I suppose, a complex convergence. So put more simply, intersectionality recognizes that prejudices and biases, even unconscious biases or biases which are under-interrogated by us as individuals, but also by us en masse as a community, that those prejudices and biases are interwoven. Inevitably, that affects the work of those of us charged with investigating, analyzing, and case building, prosecuting international crimes as much as they affect general society in general. The importance of the intersectional approach is that it creates a more inclusive framework for identities that are often under-recognized or completely unrecognized, and therefore at greater risk of being excluded from the processes of the international criminal justice experiment. With the commission of crimes, both domestically and internationally, marginalized groups both suffer higher rates of violence and also reduced successful interactions with the justice system. And that can be understood as ensuring that their what happened to them is properly investigated, properly recorded, that it's taken seriously, and that it forms part of the analysis and understanding both of how the crimes are committed and the strategy of the perpetrators, and then make their way, hopefully, into indictments where prosecutions are a possibility. I would go so far to say that the history of international criminal accountability is really a narrative of a struggle to embed intersectional approaches to investigation and prosecution into these processes. This is very ongoing. It's actually a relatively, I think, new process, starting, I would say, in the mid-90s, although domestically in the US, Black feminists were pushing this forward even before Kimberly Crenshaw had named it, as she herself acknowledges. The one thing to emphasize that not only is it an ongoing process, but it is actually a non-linear process. So often when we speak about intersectional approaches, and I'll speak about it a little bit more, is we're not necessarily making we're making progress in a linear fashion. There are routinely setbacks, and you can see that in some of the jurisprudence of the ICTR, which I'm not going to go into at the moment, where successes, gains are actually temporary, easily lost, so it requires consistency and attention, and also embedding the importance of intersectional approaches within a community wider, I would say, than the feminist community, where I think the initial discussion kind of resides, particularly in the Black feminist community. So what does that actually mean in practice when you say the history of international criminal accountability is also a narrative of embedding intersectional approaches? One is the growing understanding that many marginalized groups are near visible in the documentation efforts, in accountability efforts, in our discussion of where justice needs to be pursued. So for example, if you think about what we know about ISIL, we don't really know that much, for example, of the experiences of the disabled under ISIL, or when we talk about the Syrian government attacks on hospitals in northern Syria or southern Syria, or Syria, we don't necessarily have a good view of necessarily the impact on the chronically ill here. And that's partly because they haven't always been a focus of particular investigation. There's also the fact that even where we have now a greater understanding of the need to include groups which were historically marginalized, and here I'm thinking predominantly of women and children, there's often a tendency to frame their experience in unidimensional ways, so that the female experience of violence is often reduced to that of sexual violence. Children's experience of violence is often reduced to that, in the case of boys, of recruitment and child soldiering, and of girls also of sexual violence. Even within this reductive approach, unidimensional approach to specific groups which have begun to surface in investigations, in analysis of international crimes, there are also layers of invisibility there. So even when we speak about recognizing a marginalized group, we have to appreciate that there are layers of exclusion and invisibilization. For example, even with the community of women, you see in Colombia that crimes against indigenous women, women with darker skin tones, were often not as well recorded, not as well investigated, even within the rubric of understanding crimes against women. This also, so sorry, I'm going on a bit, just to round up, when I'm speaking more practically about looking at investigations, developing investigation plans, there's really two kind of spheres of questions that I ask. First of, in this particular alleged crime, in this particular situation, whose experiences are we most clearly seeing? What are we centering our investigations on? And whose experiences have not been so easily admitted into our concerns and therefore into our plans and priorities? So really interrogating ourselves about who are we not seeing in our planning? Then once you get beyond that, the second area I think about is our understanding of what crimes have been committed against particular individuals sufficiently nuanced? Are we framing our understanding of victims in a manner which is reductive, and are we risking rendering invisible from our investigation a wider span of crimes to which they may have been subjected? So I think intersectionality then is that framework that allows us to ask these questions, to recognize that there are marginalized communities who are unrecognized, and within those marginalized communities, there are degrees of exclusion. And that it then, once we enter into the framework, we are, I would say, ethically obligated to reflect on who and what has been left out of our understanding of events. Thank you.
Thanks, Sareta, and thanks, Max. I really like some of the things that have come up there, especially Max, you said about honorably and honestly doing this work, and Sareta, just the ongoing and non-linear journey of intersectionality, because I think that's exactly why this discussion is so important. You also raised some important questions like whose experience are we not seeing, who's being marginalized, can we, are marginalized groups visible, which leads me actually to my second question, and this one is for Valerie first and then Priya. In addition to the questions Sareta's raised about we should ask ourselves these questions as we do this work, how else can we ensure an intersectional approach to investigations and prosecutions? Valerie, thank you.
Thanks, Angela. And also thanks to Max and Sareta for setting the stage so nicely. I think that as we think about the ways in which we can ensure that an intersectional approach to investigations and prosecutions takes place, we need to recognize that forethought and advanced planning is incredibly important to ensure that intersectionality doesn't get lost along the way. So this forethought and advanced planning needs to happen from the very beginning. So if we think about leadership, often the very first people who are put into place, are appointed or hired, are the top individuals. So think, for example, like chief prosecutors or chief investigators. And these people need to be carefully selected. We, as an international community, need to ensure that they're gender competent, that they understand the importance of context, and that they understand the impact of intersections in survivors' identities and in perpetrators' targeting choices. Then, having thought about the leaders, the next thing that needs to happen is close attention to the hiring or the appointing of staff to fill out the office, whatever office it is, because the leaders need to ensure that the competencies are put into place so that their teams are able to implement the best practices and lessons learned that we have gathered over the last 20 years in international criminal law into sensitive, respectful investigations and prosecutions. We have so many lessons learned, so many best practices that can be drawn from the International Criminal Court, the International Criminal Tribunals for the former Yugoslavia and Rwanda, the Special Court for Sierra Leone, the Cambodia Tribunal, and other tribunals and UN commissions of inquiry and mechanisms over the last number of years. So taking all of that into account, then the hiring and appointing that needs to take place should also be done according to the needs of that particular situation, which requires a diverse team with local and domestic knowledge. So local meaning of particular places in a conflict, for example, or mass atrocity, and domestic meaning in the country in which the mass atrocity or crimes have taken place, so that team members are genuinely and intentionally curious and humble. And let me give you one example. In my experience, the positive advances made by the Special Court for Sierra Leone came as a result of putting into place staff who understood or who came from knowledge in 3 different areas. First, knowledge of the history of the armed conflict. Secondly, knowledge of the cultures, the numerous cultures within Sierra Leone. And thirdly, how to approach investigations and prosecutions from a gender-sensitive manner. And when the teams brought together people with these competencies, and sometimes there would be one person that had all 3 of these competencies, but more often it would be a number of people brought together with these competencies, that led to positive breakthroughs in terms of intersectional understanding of what happened in that conflict. Now, I'm not saying that the Special Court for Sierra Leone was perfect, but where these 3 aspects came together, that's where we saw more success in uncovering the harms that are intersectional than in other examples. But then the next thing, having thought about the hiring and the appointing and creating of a competent team, is to think about process. Process is so much more important than many people give credit for. Process is key to sensitivity on many levels, gender sensitivity, uncovering intersectional harms. And so it's really hard to recover from bad process. It's really hard for an investigation or prosecution to become intersectional or become gender sensitive when the process that needs to be in place to make it so was not put in place from the very beginning. So by what I mean by this is when there's too much hurry, when there's a poorly planned start, and that poorly planned start doesn't pay enough attention to pre-existing discrimination of all types in a country or a region, and how that discrimination may have informed the perpetrator's actions. Also, where not enough attention is paid to the culture in which the armed conflict or mass atrocities occurred, that can lead to a poor start and poor process. And also, if there's not enough attention paid to the ways in which individuals and groups in that society may have been impacted differentially by the crimes that took place. That can also lead to a poor start. So pre-planning is key. Maybe that's my biggest message today. Pre-planning is key. But it also requires investigators and prosecutors who are open-minded and willing to set aside assumptions, because here again is where there are pitfalls in terms of not seeing intersectionality, because assumptions can lead people to make conclusions that they already expect. And in doing that, they miss what's right there in front of them. So I'll give you another example from the Special Court for Sierra Leone. The chief prosecutor expected to see sexual and gender-based violence committed against women and girls because there were widespread and credible and true reports of such violence coming out of humanitarian organizations and Sierra Leonean civil society, which is great. But it led to another assumption, which was not so great, which is that men and boys were not subjected to sexual violence. And thus the charges in that court were framed around sexual and gender-based violence committed only against women and girls. Testimony in court then revealed that men and boys were subjected to sexualized torture and mutilation in certain cases. And relatedly, kind of a side effect of the original assumption that women and girls were the focus of sexual and gender-based violence, it meant that women and girls were less often asked to provide evidence about crimes not related to sexual violence. Sareta mentioned this, even though they had much to tell. So there's a lesson in all of that. And then I guess I'll wrap up with a couple more thoughts, which are that being open-minded requires intentionality to ask who is being left out of the process, and to ensure that then once that's discovered, that those who are left out are brought into the process. So this requires consultation and engagement with survivors groups and others who have a stake in that international criminal law prosecution, so as to give them time and space to bring that knowledge to the table, to inform investigations. And perhaps Max can talk about this later, but the Special Court for Sierra Leone, Sierra Leone's prosecution office did this sort of consultation with survivors of forced marriage. And this need for intentionality means that community outreach by courts and tribunals is incredibly crucial and is not just a luxury. It's not some kind of added luxury in the budget. It's crucial. And intentionality requires investigation and prosecution teams to identify and work through different barriers that they may encounter. So whether it's physical access barriers for those who are disabled, language barriers, insecurity barriers. And my last point is then we need to think about framing. And this is framing of the cases and framing of the charges, because the framing needs to be nuanced so as to capture intersections in terms of harm done and those who are targeted. When thinking about nuanced framing of charges, the crime against humanity of persecution can be really helpful to capture intersectionality. And in terms of the best practice, the International Criminal Tribunal for the former Yugoslavia frequently used sexual violence, frequently included sexual violence evidence within persecution charges under crimes against humanity as a way to help situate that sexual violence within the context of numerous intersections of identity, gender, and age, for example. And lastly, just to wrap up, that survivors and witnesses need to have the language to be able to express themselves. If we're going to have a truly intersectional collaboration, then survivors and witnesses need to be able to communicate both to the investigation and prosecution teams, but also to courts and tribunals or investigators who are compiling reports, what happened to them in a way that can be understood in a larger sense. So this might require a tribunal-specific lexicography, an agreement that certain phrases used in certain cultures can be linked to or provide evidence of proof, for example, of rape, because in many cultures around the world, euphemisms are used to describe rape that, if they're not understood, can easily slip right by an investigator or a court that is not attuned to that language, the way in which survivors may be expressing themselves. Now I've said enough. I'll turn it over to Priya.
Thank you, Valerie. Priya, over to you, please.
Very much. Can we just build on some of these points that have been made so eloquently by the other discussants? We've had the issue of intentionality being raised as part of the process of investigating and prosecuting international crimes. There's also been the issue of not leaving out individuals and avoiding invisibility or invisibilizing and assumptions. And against this backdrop, as I was preparing my remarks for this session, I asked myself, in the work that I've done so far, what does intersectionality mean to me? And interestingly, the response I came up covered a lot of these points that the other panelists have already raised. For me, an intersectional approach avoids rigidity and presumptions. It requires curiosity and humility, and it demands that us as practitioners truly listen to survivors and are led by them to create the conditions that surface intersectional perspectives, their experience and harms. So it's with this words in the background that I started thinking about intentionality in the context of prosecuting or investigating international crimes. One aspect of intentionality is acknowledging that each survivor or victim is an individual. This ties in with what Max said about a victim-centered approach. And it is avoiding the assumption that all survivors or victims speak in one voice. This might seem obvious, yet time and time again, this is a pitfall that we face in the field of work that we do. It's something that we have to be intentionally alert to. It's certainly a challenge I faced when I was working with UN Women in terms of operationalizing reparations for survivors of sexual violence in the Kosovo conflict. What processes do you put in place to ensure that the diversity of victims and survivors' viewpoints and voices are captured? This issue, of course, is not just limited to cases of reparations. It is an ongoing issue. How do we provide the space for victims and survivors to share the depth and breadth of their experiences, I should say, in the context of prosecutions and investigations? Another way to approach this question might be to say, what are the barriers in place that prevent survivors and victims from doing so? Valerie already alluded to this, and linguistic barriers being a very, very significant aspect. It's of course easier for us to investigate when we have a common language, and depending that the language you speak best, it might be easier to engage with victims or survivors who speak English, or to engage with well-established international NGOs who report in English as our main intermediaries. That's the convenient way to proceed, but an intentional approach would ask us to go beyond and to take steps to determine or to ensure that there is a diversity of voices who sit around the table when we conduct the consultations or the focus groups or the workshops. And I would say that the decision to conduct such consultations is important, but equally significant is determining who has a seat at the table. And related to that is the idea of intentionality in ensuring that it's not the most privileged or those with most access, whether that's related to linguistics, that are given that access in terms of expressing themselves. So that's the first point I would make in relation to intentionality in our work practices. But related to that is another issue, and I think one of the previous discussants in the first webinar noted that the methodology of intersectionality is not only self-reflection, and that relates to, for example, being intentional in ensuring diversity of voices, but it's also operational. And Valerie set out some examples of how operational decisions have an impact on intersectional outcomes. And I would like to add to that, linking intentionality and operational structures. And to do this, I would take the example of the III Syria, where I used to work, referring to its mandate, where at the outset, it was set out in the mandate or the terms of reference that the mechanism shall take appropriate measures to respect and ensure crimes or processes relating to crimes involving sexual violence or gender-based violence. So at the outset, when the entity was set out, this prioritization was provided, and an explicit call for including experienced staff with expertise in this area was also included. So when we talk about operational intentionality relating to intersectionality, this would be a good example because it enabled matters relating to gender to be incorporated right at the outset of the work of the mechanism, which again, as professionals in the field, we know has not always been the case. And in fact, the reverse might be true, where we are often playing catch up in terms of including sexual and gender-based crimes to indictments or conducting investigations further down the line, sometimes a bit too late. I think I will leave it at that and turn back to Angela.
Thank you, Priya and Valerie. Some very good points there. Intentionality, operational considerations, dangerous assumptions like women are victims of sexual violence and don't contribute any other evidence. These are all very, very important things that we've seen come up repeatedly. So thank you for teasing those out nicely for us. Valerie, you touched on something that I'm going to link to my next question, which is team composition. We've all worked in these places where people don't value two things, the diversity of the team and also an intersectional approach to the work that we do. I mean, I don't know how many meetings I've been told where adding women to the team is just politicizing this and this is so unnecessary and why do we have to do this? So knowing that how harmful these practices are and this mentality, how do we get these people to appreciate A, the value of a diverse team, and B, the importance of an intersectional approach? And it's not an easy question, but Sareta and Priya, this one's for you. Sareta, shall we start with you, please?
Sure. Thanks, Angela, for that that incredibly softball question. One thing I would say, there are people that don't see the value of having an intersectional approach, or even the value of diversity, writ large, which is related but distinct, or view with exhaustion even the opening up of this discussion. One thing I would say, and I do feel torn about this, because having a more diverse team is incredibly important in entrenching intersectional approaches in practice. It shouldn't necessarily be that way on a theoretical level, but that is the way that it has worked out. We see, for example, even when just looking at understanding women as a marginalized group in the mid-90s, that a lot of the pushes to include the experiences of the female experiences of international crimes, including and beyond sexual violence, has either come from the outside. So you have, for example, the Feminist Coalition's amicus brief in the Akayesu case in the mid-90s, or from progressive women on the inside. So you have, for example, female leads in this, the Focha case in ICTY, apologies if I'm pronouncing that incorrectly, the influence of Judge Pile in Akayesu, or of Cecile Aptel, who's a legal officer that wrote the section on a gender analysis of genocide there. We see it, and as I said, this is not a look back at the 90s. We can see even, now, last year, this year, in the Branch 251 case against the 2 Syrian intelligence officers in Koblenz, Germany, the prosecution had indicted murder and torture crimes against humanity, but initially indicted sexual violence, which took place as part of the same kind of attacks in the same time frame, same context, was only indicted under German criminal law. So it was only as a result of the submission of Syrian female activists and others, including ECHR, many progressive female allies there, that the court eventually charged sexual violence as a crime against humanity. So you can't understate the importance of, and that is just looking at women's experiences. Obviously, intersectionality would cast that prism much wider, of having diversity in the team, and also not just diversity, but diversity at more senior levels and more levels of influence, which is something I think often isn't noted. Why I feel torn about this is that, it places on people who are already marginalized within the structures the additional responsibility, not only of ensuring that marginalized groups writ large are included, but they are also then somehow also educating their peers for whom intersectionality has not yet kind of appeared in their view of the world. That it still troubles me, and I'm not sure how to manage that all the time in my day-to-day life. I've been on many committees on diversity and gender, and in fact sometimes those committees are the least diverse in that way, that you have the same people showing up to those committees each time, and are often very extremely busy people. So I myself am more, when it comes to ensuring that people are educated and understand the importance of intersectionality, I am much more a stick than a carrot person, because personally I feel that women and others, women and others from other marginalized backgrounds already do a bulk of unpaid and unrecognized work within the structures of international criminal justice. There's quite a lot of information out there for people to motivate themselves to read it. And so I focus really on ensuring that there is enough people at all levels, particularly at mid and senior levels, that it becomes inescapable, that you can't really function within the organization if you haven't taken it upon yourself to educate yourself. And if at the beginning you have to pretend to care as a route to eventually caring, then that's probably the route you have to take. That's my my personal approach, which I think not everyone would have. But I think that's, aside from that, I would also say, aside from just, it's a good thing to try and see the full panoply of people who've suffered horrific atrocities, rather than just people that look like you, or that you've embedded in your psychology are more relevant or more deserving of attention, even if that is not something that you fully recognize yourself, or would actually recoil from if you did undergo that process of self-interrogation, which all of us do. It's also really important for actual investigation. That the investigation in terms of actually, for example, I look at ISIL crimes. If we are only looking at how ISIL and the Yazidi genocide really affected, for example, men and boys, men and older boys, so even within the community of children, the ones that are older, really, I think it would be doubtful whether a genocide finding would have been reached if we'd really understood how ISIL had these coordinated actions in order to destroy the Yazidi community in different ways. And we would never got there but for an approach to an investigation of crime which really teased out communities, that didn't render women simply as witnesses to killings, didn't just look at children as being boy soldiers. So it really goes on to, are you able to do this job properly and appropriately? Are you really bringing international criminal justice to the communities, but also on a more theoretical structure, the concept of international justice? Can you do it without an intersectional approach to it? And I don't think you can. I don't think you can do it well anyway.
Thanks, Sareta. Priya, your thoughts on this, please.
Just my thoughts on diversity in a team. It's another heartful question, Angela. Thankfully, Sareta set the scene, and we've all, I think we all broadly agree, that diversity in a team, despite the limitations, is the way forward. But within that sort of general statement, I wonder if we could drill down somewhat in terms of these diverse individuals. I wonder whether there is room to think about values that we might want to practice as members of a diverse team. This goes back to what Valerie mentioned at the outset, values such as humility, values such as curiosity, which then allow us to truly hear and act, and as such avoiding the rigidity of assumptions, etc. So there's a question of values that I think that we could add to the discussion. There's also the question of competence. And we've seen this in relation to gender over the years repeatedly, discussions about gender parity within the team, but not only that, discussions about gender competence as well, because you could have a team that is, that demonstrates gender parity, but it's stating the obvious that all members might not be gender competent. And I wonder if there is scope to have a similar discussion in relation to intersectionality, where we talk about diverse teams. I think in relation to intersectionality, we necessarily would want intersectionally aware or competent team members, for want of a better term. We can nuance that, but that's another aspect as well. There's values, there's competence relating to intersectionality. That's not just the question of having a diverse team. It's who you are, and it's also how you relate to each other as team members, and how do you relate to survivors and victims. And here we come to another significant issue on intersectionality, which is our positionality. Who are we? Who am I? What are my privileges as this person doing this job? Who are my team members? What are my biases? Who am I interacting with? What conditions and what challenges do they face when they come here to give me testimony? What are the language barriers? What are the security issues? What have they given up to give me an hour of their time? These are all questions relating to positionality. And again, I think this issue of positionality has to be another underlying feature for those of us who are interested in furthering an intersectional approach in our work. And I've talked about positionality in relation to, say, practitioners and survivors and victims. But I would also like to highlight another significant aspect of positionality. And I think that's positionality within the team. And if we're trying to have diverse teams, that necessarily means you are going to have individuals from very different backgrounds, very different experiences. And how do then team members interact amongst each other? Because clearly a diverse team is not devoid of the power structures and hierarchy that we're trying to address when we deal with survivors and victims as well. So all to say that the diverse team is a starting point, but within that, we can look at values, we can look at competence, we can look at positionality amongst each other, and clearly, within our main stakeholder group who are victims and survivors, and of course also all other stakeholders, and that could include civil society organizations as well. So I'll leave it at that. I think I've just answered the point relating to diversity in a team. If you want me to go on a value of intersectional approach, I can, but I'll leave it at that for now, Angela.
Thanks, Priya, and thank you, Sareta. I think some very important points have come out. The values, team members who are curious and humble, competence, so important, and not just, competence that exceeds your qualifications or experience, but as you mentioned, gender competence as an example, and positionality within the team. What are our privileges? What position do I put my fellow team members in? So these are all just such crucial points. Thank you for bringing them out so clearly for us. I'm going to move on slightly because what we've talked about now, these elements, they mix well with investigations and prosecutions. There's like a thread that is consistent throughout, but I want to focus on intersectionality with regard to prosecutions. And Max and Valerie, for you, and let's start with Max on this one. What does a lack of intersectionality look like in the courtroom? Because this is where it plays out in the end. Thanks, Max.
Sure, thank you. By the time you get to the courtroom, it's almost too late. And I think that that's, thinking about this subject, because of course, we prepared, we discussed in advance, and we talked about how all of this plays out in the courtroom. And I truly, truly believe that the way it will play out in a courtroom is directly related to how intentional we were at the outset, how much we included this at the beginning, because from the moment that you take a witness statement, or from the moment that you put together the first brief, if an intersectional approach is woven into the fabric of the entire process, then it might even make its way in a healthy way into the courtroom without the judges even realizing that something is going on. I don't mean to be disrespectful, but to be honest, we frame the narrative. Those who litigate, we as prosecutors frame the narrative. And if we frame the narrative in a way that comes directly from the survivors, and it's their narrative, it's their words, and if the questions that are asked and the listening process is done with embedding intersectionality into every aspect, just like you've all set out, then the case will necessarily have an intersectionality approach to it. And it doesn't mean we will succeed on every charge, or that that the victims will get ultimately get the exact justice that they sought. But even if they don't, the spectrum of their harms and their experiences will be highlighted in the courtroom process. And that is, I think that is what is critical. The whole topic is really about listening, and I'm pulling out some of the things that many of you have said as well, right? If we go back to how we get to the courtroom, if we listen as well as we talk, or we listen more than we talk. Valerie, you were asking me to talk about Sierra Leone. I don't think this is what you were intending, but but in Sierra Leone, the community consultation and outreach was such a pivotal foundation upon which everything was based. It was almost like when I left the special court for Sierra Leone, it would never have occurred to me that you could do any of this without a very deep and centrally placed community engagement process. It wouldn't have occurred to me to talk about it because I actually thought that that's how international justice is done, because that was my first experience. And like you say, Valerie, there were mistakes that were made, and but there was no question that the justice was for the community and that we were servants of the affected community. There was no question about it. That was in the very fabric of everything that we were doing, and as a result, taking any step without a consultation with the community would have been unthinkable, because who are we to take that decision? So that comes with the humility, but if that's embedded in the practice from the beginning, so sometimes these discussions with witnesses, and I'm not only talking about victim witnesses, I'm talking about insider witnesses. Sometimes they would take hours and hours in order, before you even start on the actual interviewing, to explain, to understand, and to learn about the context. And even though the special court process looks now from this perspective like it was very, very short, very fast. We were on the ground, and therefore, and there was never any pressure on time to interview faster, or no, you can't have another day with that witness. Everything was all about doing what needed to be done in order to listen and hear and learn. And that was the only way that the practices, the customary traditional practices of the affected community could have been handled in a courtroom, because every witness would testify. For example, every witness, I was a lead investigator on the civil defense forces case, and there was a very strong spiritual belief amongst the community. And so the witnesses were going to come in the courtroom, as they did, and testify to what we might call magical events and occurrences, like bullets bouncing off somebody's shirt after they were bulletproofed. Now, if you do not listen and understand the community before you litigate that case, every witness is going to be escorted out on a lack of credibility. And that's only one example, but so I think listening is absolutely critical. Listening requires time and money to be invested in the community engagement and listening process. And that involves everything that we're talking about. So that involves first our self-reflection, then the composition of the team, then building competence on intersectionality and everything. We go through all of that. That all takes time, and it all requires money. And if you have any justice process that doesn't feel the need to invest in community engagement, then that is, by its nature, that justice process is not going to effectively serve the victims, let alone serve them in a way that takes into account the multi-dimensional experiences and identities that they've experienced. So listening, time, money. I think if we look at the Habre case, I think there was 10% of the budget went to outreach. The fact that outreach is sort of a side issue now, I don't really how can you bring any justice if you put the community engagement and the community consultation part as an extra, like with your PR department? There's something fundamentally and principally wrong with that. Language, and on language, and some of you mentioned language, but I think language is absolutely critical. And in order to deal with language in the most respectful way and make sure that we have embedded intersectionality into everything that we're doing with intentionality, you need to invest in language from the very beginning. And if you try to take a shortcut on that, then again, we're not only not victim-centric, but we're not bringing justice in a way that serves the affected community. One example that I have to cite is, we hail the incredible, and with good reason, the incredible successes in Guatemala. In the Seprosarco case, we worked, PJI, we worked to support the prosecutors in that case, and they had an outstanding result for the first conviction for sexual slavery crimes committed in the 1980s. And it was an extraordinary process, of course, led, as you say, Priya, by the communities themselves, right? The ones who are bearing the burden of the lack of intersectionality and are now responsible for, but okay, they did it, right? Brilliantly for decades. They finally get the case going. It's finally in the court system, and the translation. So I don't know, 20% or something of the population of Guatemala is Spanish speaking, and the courts are run in Spanish, and none of the affected community speaks Spanish. And they translated only the direct testimonies of the victims. So if a witness would testify, they would get somebody sitting next to them who would whisper and then communicate with the judges. But there was no live simultaneous translation to the community, which meant that the community literally couldn't actually follow. I mean, they were following, they were in the room they were listening, whatever they could listen, but they don't speak Spanish. And many of them are elderly indigenous women from the community from rural areas who've never even been to the capital before this case. And this is so the system, what happens is that there was the process of building the case was all community focused, but the ultimate courtroom, and you're asking about the courtroom, by the time they actually got into the courtroom, it was not accessible to them because it was not translated. And there is something for me that's so powerful about that, right? I think that that's a lesson that we have to take, and I don't mean to criticize that because it was a brilliant success. And yeah, I mean it's something we always talk about in terms of a major success for justice, for gender justice, and accountability generally. Okay, but the language issue, it still bothers me. So I think I'll pause there. I probably went on too long.
Thanks, Max. It's a very powerful example. Famous in court. Valerie, please go ahead.
Sorry, Angela. I just wanted to pick up on that actually, because it's so linked to the 2 points that I want to make, because basically what you're talking about, Max, is what Priya was talking about positionality. So positionality in the courtroom, that requires thought. And the courtrooms are generally set up in extremely hierarchical ways that in and of themselves can help stamp out, unfortunately, bringing out intersectionality. So everyone who is present in the courtroom needs to think about their positionality and see how that courtroom process can be adapted in order to allow for the voices of those most affected to actually come through in their fullness. So let me give a little really small examples of what I'm talking about. I'll go back to the special court for Sierra Leone again for an example of how a breastfeeding mother was accommodated in the courtroom so that she could take breaks for breastfeeding and allow for childcare while she is giving her testimony. It's a small way to respect the fact that she is not only bringing testimony about being a girl who was subjected to sexual violence, but she is now a mother with childcare responsibilities and doesn't have the resources in order to do anything other than, and may not wish to do anything other than have her child close to her. So that's one way in which her intersectionality can be respected and was respected. And another is for courtrooms more generally to allow support people in, support people to assist those who may be suffering from a disability, who are also bringing testimony to the court, those who and that could be a physical or mental disability. So these are small examples, but they can go a long way to ensuring that intersectionality of identity can be respected in a courtroom. And then I'll give an example in response to where we can see intersectionality in a courtroom not playing out the way that we're advocating here today. And that is when, and this has been mentioned before, when assumptions about why a witness is in the courtroom end up limiting that person's ability to talk about their experience to only raise one small part. So this goes to the problem of tick boxes and categorization that is part of law. Of course, a prosecutor is in the courtroom in order to show evidence that fits within the elements of crime. And so there is a tick box, right? They need to show these 5 elements in order to prove this crime. So that can lead to a mindset. Well, I'm bringing this person to serve as a witness to talk about this one checkbox. So this is all we're going to talk about. But the challenge with that is, having spoken to many victims and witnesses who have, especially female victims and witnesses who have appeared before courts in the past, and they want to talk about their situated reality. And their situated reality is not that they only suffered in an armed conflict being subjected to sexual violence. But that sexual violence occurred in a larger context. That larger context meant that they lost their house, it was burned down. They lost their livelihood because their fields were mined or overrun. Their children were scattered. Their family is all over the place in refugee camps or dead and they don't know. People have been disappeared and they witness murders and other atrocities. So when their testimony is shrunk to this checkbox, they often feel like justice has not been done for them. Maybe in one part, but they want to express themselves more fully. Now, I realize this is a challenge, but there are ways to position people in a courtroom, both metaphorically and physically, so that they can better contextualize what they've gone through in order to get to that checkbox for a particular crime. And the prosecutor may discover that that person can actually help satisfy other checkboxes as well. You know, that there are other aspects of crimes against humanity that can be demonstrated by the wholeness of their evidence. So I'll stop there.
Thank you very much, everybody. This has been fantastic. So much has come out of this. We do have a few questions from the audience, so I will jump straight into that. And the first one is, can one of the speakers expand on common issues underpinning pushback against intersectional approaches in criminal investigations by justice and policing actors? In particular, presumed conflict of rights related to freedom of expression and anti-discrimination policies, and or gender equality, affirmative action policies, and institutional meritocracy. Any takers? So the request is, can anyone expand on the common issues underpinning this pushback against intersectionality in our field? And those are just a few of the examples that were given.
Could I jump in just with one point, and I'm sure the others have thoughts as well. And that it goes to assumptions that I talked about at the beginning, where especially if someone's coming from the outside, so someone is being sent in as a police officer from Canada who's being sent in to an international investigation as one of many people with investigations expertise who are being lent by countries or being seconded by countries. And that person comes in believing that they know the way to do an investigation because that's how it's done where they're from. But unfortunately, many people have been trained not to understand how to deal with intersectionality. And so they're already coming into the investigation believing they know the right way to do it, but without being open to other ways, or even the culture in which they are investigating within. And that's problematic.
Thanks, Valerie. Max, please go ahead.
Yeah, sure. I think that the question was a little bit about police and justice sector practitioners, you know, so with PJI, we work to provide technical support at the request of national practitioners, and those practitioners also sometimes include police and prosecutors or other law enforcement at the national level. Now, by the time they ask us, of course, they're showing the humility that we're asking them to show, right? Because they're saying, okay, we're trying to investigate these crimes. We know how to investigate an ordinary murder under our penal code, but we don't know how to investigate killings as part of crimes against humanity. So can you help us? And the moment that they express that openness, and by the way, with PJI, we're finding that openness in a multitude of jurisdictions, because when they try to take their approach that they use normally and apply it to atrocity crimes, which are often happening in the past, and you know, survivors are often very vulnerable, etc., it's not working. And so they need in a way they're facing the wall that the survivors are, you know, victim community are presenting them with. and saying, no, you have to do better. You can't do this murder investigation the way that you would do, and you can't do this rape investigation the way that you would do. No, there's no rape kit. This happened 30 years ago, you know. So they have to shift their thinking. And I think it all starts, like you say, with intentionality, but it also all starts with the openness. And I think provided that there is that openness and that humility and that willingness to shift, then there isn't a reluctance. There might be a reluctance, but I can assure you that those institutions that are reluctant to make this change, at least to start to make this change, will not really be carrying out effective investigations, and those cases won't go forward. So yeah, so I think that's the response I wanted to share with respect to law enforcement and police.
Go
ahead, Sareta.
I just have very quickly, when I kind of start to analyze barriers that cause backlash, I always think about kind of structural barriers and attitudinal barriers, and those are often interlaced and also kind of mutually reinforcing. But part of it is just going, well, we would investigate crimes against children, but we don't have that expertise here. We don't have a particular expertise here, and that may be true. That may not just be an attitudinal statement. That may be a statement of fact, although underpinning it is an attitude that this wasn't important enough to dedicate resources to find the right people to do this investigation. But from the point of view that they're in the moment, that are running the investigation, that are going out and seeking people, they're not going to be in a position necessarily to interview traumatized, vulnerable members of the community that require either specific interviewing skills or perhaps don't want to be interviewed by people that they're less comfortable with, which is also an important part of the investigation process, is having a range of investigators there that you can also in so many ways cater to what the interviewees are comfortable with as they're recalling, often the most horrific moments of their and their families' lives. But beyond that, there's also the attitudinal barrier of this isn't important, or they get messages in the hierarchy, yeah, you've collected this information, but we're not going to forward on this, we're only going to go forward on this. And that's often because the experiences of those who are most easily recognized as being victims of particular crimes are more easily translatable, I think, into an investigation narrative, and then more easily translatable into a courtroom narrative. So it's also a slipstream, almost of a slightly easier time than one trying to investigate, have the resources, put resources in place, change attitudes, get people in the investigation, and then try and convince a courtroom that to recognize either types of violations or types of victims that are not usually before the court. And that leaves out, of course, the other challenges of actually getting those victims who are not generally recognized by justice systems, who haven't had positive interactions with justice systems, in getting them into a court, which is another aspect, another challenge.
Thanks, Sareta. If I can just add on very quickly to a point, Max, talking about capacity building at the domestic level, which is something I've also done. I often found that, say we had a training with civil and military prosecutors and there were no women in the room. We had to build a relationship with the investigators, get to understand their numbers, and then for the next training say, would you mind sending 1 or 2 women? And that changed everything, because it wasn't something they had thought to do, because the trainings are allocated sometimes based on hierarchy or sometimes based on the need they've identified. So there's a lot of space just to address the question from our participant. And Priya, I see you had your hand up. Please go ahead.
Quick point to build on what Sareta talked about the processes following the path of least resistance, let's put it that way, the easiest way forward. And the best example of that, I think, is the discussions that we've had in relation to sexual violence in conflict. That there has been such an emphasis in the past in terms of other crimes, for example, those considered more serious, on the basis that crimes of sexual violence in conflict were either secondary and therefore marginalized, they were harder to investigate, all these presumptions and biases that we have seen in relation to prosecuting sexual violence. And as we know, there's a huge body of academic work and work that has been done by tribunals in terms of breaking down that narrative and not following the path of least resistance. And I think that in relation to intersectionality, we are at the cusp of that process in terms of fleshing out what it is, and then taking the next steps in terms of embedding it in mechanisms either relating to accountability or investigation. And we have some good comparisons and lessons that we can learn in relation to how the issue of gender has been addressed in international criminal law.
Thank you, Priya. I have another question here, and I'll just read it to you. It says, as for the ICC, wouldn't you say that an intersectional approach is virtually prescribed by the Rome Statute's applicable law under provision Article 21.3? In that, it explicitly requires the consideration of the impartiality principle when applying and interpreting law, which must, and I quote, must be consistent with internationally recognized human rights and be without any adverse distinction founded on the grounds such as race, gender, et cetera, et cetera. So the question is, does Article 21.3 of the Rome Statute provide an intersectional approach? And before you answer that, just for everybody listening to us today, please remember to type your questions in the Q&A section of the Zoom webinar, not the chat box. Thank you. Who would like to take our question on whether section 21.3 of the Rome Statute is intersectional? Priya and Valerie, I see you both. We'll start with
Angela, who did you want to start with?
Oh, sorry. I was just saying, shall we start with Valerie and then go to you, Priya? Thank you.
Thank you, Inga. That is a fantastic question because the answer is yes, in that when this was being negotiated, and I had the privilege of negotiating this aspect of the Rome Statute, that was actually the intention of all of those who were negotiating Article 21.3 was to ensure that it captured intersectionality on many different grounds, because it would assist not only for the practice, generally speaking, about within the court, but also for the crimes against humanity provision, because those two are interlinked in terms of their underlying non-discrimination elements. Priya?
To build on that, I mean, Valerie has given the backdrop to the article. And starting from there, I suppose the process that we're embarking on now is the application and the enforcement of this article as such, as a specific example, and the concept of intersectionality as a larger issue in international criminal law. I mean, indeed, in the first webinar, there were discussions around the idea that intersectionality is already embedded in international criminal law. It can be found in the Geneva Conventions in terms of the protection of certain vulnerable groups. It's already seen in the Genocide Convention. So the legal basis, one can find, and the challenge that we see for ourselves is the proper application of the concept.
Thank you, Priya. We have another question. Do you have any practical tips for investigators or prosecutors looking at international crimes targeting persons on the basis of their real or perceived sexual orientation or gender identity? In particular, how can we improve access to justice for victims in communities with a strong stigma around LGBTQI+ status that could prevent victims from coming forward and or having safe referrals to competent services?
I can speak, maybe I can just start off this conversation. I would say with communities which where the justice system hasn't worked, but also where they're marginalized and sometimes violently marginalized from the communities of the broader community of which they are part. There are two aspects. I think the first is really just a tremendous amount of time working on outreach and trust building, picking up on what Max said. With these communities, even getting them into a room is very difficult, because we're not only speaking about a lack of trust in the system or in the individuals that they're speaking to, but also, or even a lack of trust that cases will move forward into a criminal justice system. But you also they're also the actual social cost and potentially even the cost to security of person and of life are also in play. So the risks that they are facing in coming forward to have that discussion are immense, and that means the barriers, the challenge to trust creation is also more immense, because they're not just putting their story in their hands, you're also putting together what may be very fragile relationships with other members of the community, or potentially even their life into their hands. So a tremendous more needs to be done on outreach. And I'm not necessarily, I'd be interested in kind of Max's view on this, of whether that outreach would necessarily only fall into the hands of investigators, or really be more integrated across different parts of the tribunal or justice system that are there. Because I don't know if prosecutors, it's necessary. I agree, prosecutors, investigators should be part of it, certainly, but I do worry about them having too intense roles to play in a process. And then the question is also ensuring that your team is understands the value of this investigation, understands how to approach this community, really not only sees the community itself, as in recognizes that they are deserving of being included in the process, but really also understands the experience of the community, not only of the violence that they suffered, but their day-to-day lives and how you relate to them. So it's who do you, what are you seeing? And when you see them, what aspects of their experience are you still not fully grasping? And really doing that work as individually, but also as a team when you're doing the investigation plans and in discussing these. Because I think without those two components, you don't ever move on to actually getting anyone in a room where you can have a conversation with them about what happened.
Max.
So the question that was, Sareta, yeah, no, I mean, when I think of outreach, and I mean, I think best practice on outreach would be an entirely separate unit that's fully and vigorously funded, that then can pull in different people for different parts of the outreach. So I think there are times when the president, I mean, I don't know if it's possible, but I mean, when you know, even the principals should be going out to the community themselves at times, depending, and then to have different parts of the outreach program draw on different sections of the justice system. But I think it's something that is definitely not solely, or it shouldn't even be, I think, situated in the investigations team. I think that there are community consultation aspects that should be embedded in best practice in investigations, and even in prosecutions. So I think that the broader outreach and community engagement has to be at all stages. I do feel that there is a role, that there is an obligation almost. I believe it's kind of an ethical obligation, if we're serving an affected community, to make sure that we listen to the affected community and consult with them as prosecutors and as investigators. And that is part of truly bringing tailored justice in a way that addresses all the dimensions. That said, the outreach program should be much bigger than that. And yes, a more comprehensive, fully funded project, ideally.
Thank you, Max. We have another question. I would like an outline of, there's a typing error here, but I think it's of factors one must consider when analyzing intersectionality of gender and race, particularly when assessing SGBC elements in non-Western cultural contexts. And the example they give is, for example, consent in the case of forced marriages in cultures in which there is a prominence of arranged marriages. So an outline of the factors you need to assess when analyzing intersectionality in such cases. Would anybody like to take that on?
I'll try and, okay, Valerie, go ahead. Go ahead.
Thanks, Valerie, please go ahead.
Maybe I'll just make a few comments, and Sareta, please jump in as well. So some thoughts that come to mind is considering how starting at the beginning, any prosecution office and investigation office needs to consider the role of gender-based discrimination in a society, as well as other forms of discrimination that exist in a society prior to the conflict or the mass atrocity. Because very often these inform what happens during the conflict or mass atrocity and become translated into forms of, for example, forced marriage or other forms of sexual and gender-based violence. So by starting at that point, then the investigator or prosecutor will understand the role that arranged marriage played in that society prior to the war or the mass atrocity. And by having that understanding, they can then begin to tease those two things apart so as not to make the assumption that they're one and the same, or that that arranged marriage in a society naturally led to forced marriage, because often the way in which forced marriage is expressed is different from the way in which arranged marriage is expressed. So I think it's that cultural competency that is really important for that, for teasing apart what comprised forced marriage in a given context. But Sareta, you have other thoughts, I'm sure.
Sure, we dealt with this a little bit in the Sareta case, where I was actually not prosecuting, I was in defense, so a different perspective. But the one thing I would say is I would start off by saying, I would still draw a clear line in the mind of the investigators and those who are looking, and then analysts, of something between arranged marriage and forced marriage, that we're not equating two things which are not necessarily suitable for that link. Now, within the sphere of arranged marriages, you already have, they're not monolithic. Arranged marriages take many forms, and within the concept of arranged marriage, you may have arranged marriages which actually have greater consent, and it's a complicated area, but you also have arranged marriages which are non-consensual, which are themselves both arranged and forced, either because someone has not consented and it's being done against their will, or because potentially they're too young to give a valid consent, which is also something I think we need to take in mind of, that when we're speaking about marriages, we're not just speaking about adult women, we're also, and in many cases, often speaking about girls. Here, I would always go to who are we not seeing? When you're trying to understand, I would be very reticent to put forward as a base assumption that a community in which there is arranged marriages somehow adjusts better to a forced marriage in conflict, right? I think that would be a very dangerous assumption, but I think you start to flirt with that assumption when you put arranged marriages and forced marriages into the same box without any kind of more consideration. Arranged marriages often have, as Valerie alluded to, very specific social context and social steps around meeting, around who is involved. In Sierra Leone, you had, for example, the Mami Queens in Kailaun that would often play a role in bridging gaps between the families of the woman and the families of the intended suitor. And so without those, you can't just take out, for example, the Mami Queen and put in the commander or the sub-region commander of a rebel army and so they say the same role. So that's one thing. But aside from that, I also think you're looking at what are you not seeing? So you're asking about the intersection of race and gender. It's interesting because you're looking at when you have forced marriages, marriages are taken out in such coercive circumstances that consent is not possible. Are you seeing differences in the marriages that are being forced between, for example, women of lighter skin tones versus women of darker skin tones? Do you see differences in how Indigenous communities are being treated within the rubric of forced marriage? Are you seeing actually across the sphere of sexual violence actually different crimes which aren't forced marriages? Are you seeing some women or girls, maybe pubescent girls who have lighter eyes, who have fairer skin tones, being taken into a forced marriage where there's a spousal perception, at least on the part of the people perpetrating the crime, that come with tremendous disadvantages, but some advantages within a context where there are not many advantages to be had, let me frame it that way, versus women who perhaps from indigenous communities, from darker skin tones, in communities, which is all communities where colorism is rife, even in majority non-white communities, that are not actually going into marriage, which are maybe what's happening to them is not properly designated, would not possibly properly be designated as a forced marriage, but maybe might something more akin to sexual enslavement, or in fact enslavement as a whole. So I would also look at, before you designate the crime, look at what's happening and see whether there are actually different criminal acts occurring, depending on not only gender, but on not only race, but also color and caste. So that's probably how I would approach it.
Thank you, Max and Priya. I see you both. And then after that, we'll wrap up because we have come to an end. So Max and Priya, starting with you, Max. Thank you.
Sure, thanks. Just very briefly, I think one of the ways that you can find the appropriate factors to think about, right, is first of all, by being on the ground and spending ample and sufficient time listening. And second, by having a team that includes, if you're speaking about international investigators, it sounds like you are, international investigators or prosecutors working in tandem with local prosecutors and investigators from the community, if possible. So the only way that we were able to carry out effective investigations in Sierra Leone in these communities is because we were on the ground living there full time, and because the teams had all the expertise that Valerie was speaking about and included local Sierra Leonean investigators and international investigators working in tandem. There's literally no way that as an international investigator at the time that I could possibly have investigated, regardless of whatever skill and regardless of humility and anything. There's no way that investigation could have been done in that time frame in any way that would be effective or serving the community without the teamwork with the local investigators. And so we didn't come in with an assumption about what the factors would be to make sure that we're having an intersectional approach. The factors emerged through the course of the investigation. And as Valerie points out, you can find a lot of things we left out at the time that we should have, on reflection now, that we should have included. But I encourage you to approach it that way.
Thank you, Max. Priya, you have the floor.
Building on that and the issue raised by Valerie, the structural context or the context of discrimination, pre-conflict and post-conflict. For those of us who work in international criminal law and gender-based violence, we know that existing inequalities pre-conflict relating to gender are made worse or can be made worse in a conflict situation. And therefore, the context in which these crimes were committed needs to be looked at pre-conflict as well. And related to that, I wonder whether, since we're summing up, Angela, this might be a good juncture in which to raise a final point, which relates to the significance of perhaps an interdisciplinary approach when dealing with intersectionality. In relation to the specific question, expert evidence relating to the cultural context, for instance, might be relevant, tying into what Max said in terms of working with local investigators who have ground level knowledge. So the broader point really is, how can I understand the context in which I am working in? And linked to that, as I say, is this interdisciplinary approach. We've talked about an interdisciplinary team, maybe a diverse team that has different skills. But what I would like to propose is a broader approach that is in line with our overall theme, I think, which has been to avoid rigidity in our approaches. And for me, that also means being alive to other areas of law and practice that could be relevant in terms of nourishing the work we do in international criminal law. Other webinar participants in the first session had talked about human rights law as providing that interdisciplinary approach, whether through CEDAW decisions or general recommendations. I've seen intersectionality in my work as a UN rapporteur on the working group on arbitrary detention, so in the context of human rights. But I think we can also look closer to home on issues relating to transformative justice or transformative reparations, for instance, where we talk about resolving issues relating to structural discrimination as part of the process of providing remedy. So I would just leave us with that thought, perhaps for us to have greater intentionality in dipping into other disciplines as a way to inform our understanding of international criminal law.
Thank you, Priya, and thank you all so much for such a rich discussion. And I really think what's come out here is, at the heart of it, we're talking about victim-centered justice and how to do that. Intentionality, listening, values of humility and curiosity, and weaving all of this into your planning at the investigation stage and all the way through to your cross-examination or your closing in court. I think all of these themes have come through very nicely. Thank you all so much. Thank you for those who've tuned in. Thank you for the questions from the audience. To the wonderful panel, I have no words, you're all brilliant, and thank you to the organizers. So on that note, I will close this discussion and hopefully see you all for webinar 3. Thank you.